Any mention?
May I please, Lordship? I beg to mention item number 16. This matter come up after 3 weeks, Lordship.
Yes. What is matter?
It is quashing matter, Lordship.
After 3 weeks.
Yes.
No objection, Your Lordship.
No objection, Your Lordship. I'm for
Well-
private respondents.
The prayer made on behalf of the at least after 3 weeks. Yes.
Much obliged, Lordship. Your Lordship, I beg to mention item number 8, Your Lordship. Your Lordship, this matter can come up after 2 weeks, Your Lordship. After 2 weeks, Your Lordship.
I have no objection.
That is that matter where you said some sort of.
But we could not work out on a settlement. Right?
It is. Is this pertaining to what issue? What was the thing?
My lord, basically, my lord, there is a delay in taking cognizance of the FIR. Relates to bonded warehouse. Some levy I was supposed to pay. For non-payment of levy, my lord, FIR has been filed. After a certain number of years.
So issue here is the delay.
Delay. My lord. Delay in taking cognizance.
It is beyond the prescribed period.
Beyond the prescribed period. That is my case. My lord.
Okay. How long?
2 weeks, Your Lordship.
The request made on behalf of the.
Much obliged, Lordship.
Okay, for the state respondents.
Yes, Your Lordship.
Yes. Okay. The request may also not objected to by the petitioner. List of 2 weeks. Yes.
Much obliged,
Obliged.
Lordship.
May it please, Lordship. Lordship, I beg to mention item 10 and 11. Lordship, I plead for 2 weeks' time.
10 and 11 are connected.
These are connected matters.
Connected matter, 10 and 11.
Again, quashing.
My lord, this is a criminal revision against the conviction by the Juvenile Justice Board.
Okay. Conviction. Is conviction. And what is the length of detention? 2 years. For how long?
3 years.
3 years.
Eleven I'm appearing.
There are 2 accused.
No,
2 yes.
Okay. How long?
2 weeks, Your Lordship.
No objection.
no objection.
Same order on the prayer of the petitioner, not objected to the judge.
Deeply obliged.
Yes.
May I please, Your Lordship, I'd like to mention item 24, Your Lordship.
I'm appearing for the sole respondent, Your Lordship.
Yes.
I have no objections, Your Lordship.
I pray for 2 weeks' time, Your Lordship.
This is what? Maintenance matter?
No, Your Lordship, this is revision petition, Your Lordship,
Revision against?
against the impugned order by the
Oh,
district.
this is a civil revision.
Yes, Your Lordship.
Okay. 2 weeks.
Much
All right.
obliged,
Your Lordship, I beg to mention,
Yes, this is petition, not the request of petition. Item 24.
Yes, I beg to mention item number 17 and 18.
Lordship, I'm appearing for the state in this matter.
Lordship, Mr. Paske is on leave. I pray for 2 weeks' time, Lordship.
17 and 18.
18, I'm appearing, Your Lordship. In
I'm appearing in 17, Lordship.
I'm for the private respondent in both the matters. 24.
Okay, private respondent. Okay. Petitioner.
Yes.
You are the petitioner. No objection.
No objection, Your Lordship.
Okay. So we'll, Madam, we'll adjourn
Yes, Your Lordship, no objection.
after 2 weeks.
2 weeks,
2
Your
weeks.
Lordship.
This is also on the
Similar
request
brief
made
for
on
item
behalf of the
21,
High
Your
Court of Meghalaya. You just record the name of this thing. Dr. Puja Agarwal is there in the thing.
21, I'm appearing,
After
Your
2
Lordship,
weeks.
for the state respondents.
Yes.
Your Lordship, in item 21, I'm for the petitioner.
Yes.
Lordship, I don't have any objection because my friend has already informed me yesterday. But the only submission that I would like to make that Your Lordship,
Item 21.
the item
Yes.
21, matter has been pending for quite some time, a lot
No,
on the
but then
same issue.
We've more or less, Your Lordship, completed the hearing also. We were on the case laws, Your Lordship. Then on the last date, Your Lordship, they were directed to give their FIR along with the annexures, which we have received, Your Lordship.
We have filed an
Because
affidavit.
FIR had
Okay,
been
the
filed
annexure
without the
was some
annexures.
annexure was
So that we have received now, Your Lordship. Now the matter, on the next date, we can conclude the matter.
So when shall we have it then?
After
After
weeks.
2 weeks, Your
After
Lordship.
weeks. Lord.
After a week, we do not know. After a week may not be
Because
possible. It will
next week we have only 3 working
Lordship.
days. Yes, Your Lordship. Even 18 and 17 are connected matters.
So this, those matters have gone after 2 weeks.
Yes, Your Lordship. So let
We'll
this
also
come
have it
after
after
2 weeks, Your Lordship.
This is also just after 2 weeks on the request made by the parties. Yes.
Your
Like-
Lordship, similar brief for item 20.
Item?
20.
Item?
20, Your Lordship. I'm appearing for the petitioner.
20. Yes. You are for the petitioner?
Yes, Lordship.
Yes.
No objection, no.
So, yes. One prayer made by the petitioner and list after 2 weeks. Yes.
Obliged, Your Lordship.
May it please, Your Lordship.
Yes.
Lordship, I beg to mention item number 23. Lordship, in this matter, I appear for 2 weeks' time.
Item 23.
23.
Yes.
I'm for the petitioner.
You are appearing for? You are for?
Respondent number 3, Your Lordship.
Last number 3. And who is the state?
Yes, my lord, I am there.
Yes.
No objection, my lord.
So when shall we have it?
2 weeks, Your Lordship. After 2 weeks.
But my lord, I mean, we've been taking time I mean, of course, I took time last time, and of course, I don't have an objection to this time, but if we can give them a last chance to say that we are ready for argument.
See, there is nothing called as a last chance. You see, like,
Okay, my lord.
2 weeks. You see, if it is last chance, then first
I
last,
understand.
second last,
I
third
understand.
last,
I understand.
last and final choice.
I understand, my lord. It's just that
There is many difficulty. You see, like you give a last chance and subsequently in the next day,
Yes, my lord.
very genuine issue comes.
Yes.
Then becomes difficult. This court has to violate its own order.
Okay, I buy on order.
Just if you have this thing yourself.
We'll agree. We'll agree to something. Next year.
Just on request made by Learned Council, paying for the rest of number signs after list after 2 weeks. Yes.
May it please, Your Lordship. Your Lordship, I beg to mention item number 13. Lordship, I'm praying for 2 weeks' time in this matter.
Your
Lordship, item number 13.
yes.
No
Any
objection.
Just on the plate. You are for the Union of India.
Yes, Your Lordship.
Just on prayer meet on behalf of known as DSGI. This is not objected to by the Learned Council of the petition. List after 2 weeks. Yes.
May it please, Your Lordship, I beg to mention this item number 14, Your Lordship.
Item
14. In this
yes.
matter, we are supposed to get instruction, Your Lordship. We have received the instruction.
With regard to what? Instruction with regard to?
Respondent number 4 and 5. They have expired, Your Lordship.
Okay, they passed away. Okay.
Yes, Your Lordship.
So,
We have received and so we'll implement them, Your Lordship.
so what is to be done now?
We'll implement them. This we have received. We
You provide an application for implement.
No objection.
and
You're-
also,
You
and
are
also,
appearing for or the?
For KHDC, my lord.
Okay.
1 and 2.
Respondent number 6, yes. Respondent number 6.
Yes. How many? But then you said
respondent
who?
number 4 and 5.
4 and 5. The 6 is another person, private respondent.
And with regard to respondent number 3, we have taken steps, Your Lordship.
And you take necessary steps. We'll just simply adjourn it on your prayer.
Yes, Your Lordship.
That will all? Yes. Just one prayer made by the petitioner. Not object to the Learned Council of the respondents. List after 2 weeks. Yes.
Much obliged, Your Lordship.
May it please, Your Lordship. Your Lordship, beg to mention item number 15. Lordship, I'm praying
Yes.
for 2 weeks' time in this matter.
No objection.
One prayer made on behalf of the petition. List after 2 weeks. Yes.
Much obliged.
May I please proceed? I beg to mention item number 12, Lordship.
Yes.
May this matter take up after 2 weeks, Lordship.
No objection, Your Lordship. I'm appearing for the sole respondent, Your Lordship.
Yes. 12 also. 2 weeks. On the prayer. Yes.
Much obliged, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 5, 6, and 7, Your Lordship. I'm
5,
praying for 2 weeks. 5,
5?
6, and 7,
5, 6, and 7.
Your Lordship. I'm for the respondent 5 and 6 in item number 5, Your Lordship. I'm praying for
I am
2
for the
weeks.
petitioner, Lordship.
Praying for 2 weeks' time, Your Lordship.
I am appearing for. These all are connected matters. 6. These are service matters.
Yes,
Connected matter.
matter has been already hard, my lord. Only
See, you'll find almost all the items in the hearing list are hard. This is a service matter related to recruitment.
This is the post, yes, post of Hindi teacher.
Okay, in a school, in an aided school.
yes, it is already abolished.
So why 3 petitions?
Because these are 3 different petitioners, 3 different schools.
In all the schools, subject matter is Hindi post.
Yes.
Okay, then the prayer is made on behalf of the school,
School Managing Committee, Your Lordship.
school managing committee, in all three matters.
No, Your Lordship.
I am appearing for managing committee in item number 6, my lord.
In item number 5, I'm for the School Managing Committee and the private respondent, Your
So
Lordship.
okay, and item 6?
Item number 7, I'm for the respondent number 5.
And item 6, you are not a party.
6,
So you in 5 and 7,
5 and 7.
it is your prayer to adjourn.
Yes, Your Lordship.
Just record her thing on prayer made on behalf of respondent number so and so in 5 and 7. And in 6?
6 I am appearing for managing committee.
So what is to be done with 6?
Yes. Huh?
Are we passing separate orders in this thing or you are passing common order in this matter? In all matters, the previous orders are common orders. These are is a common orders in this case.
Lord, because these 3 matters have been
Yeah, but then if respondents are different, then how do we record the prayers and all?
there is an
Okay, the rest are list along with these things. Okay, then in item 5 you just say on the request made on behalf of so and so, London Council appearing for the private so London Council for the private respondent so and so. This is matter after 2 weeks.
2 weeks, Your
And
Lordship.
these other 2 matters we just list after 2 list after 2 weeks. Okay.
Lordship, in item 7, I'm appearing on behalf of the petitioner.
Yes. You have any objection to that? We'll just those matters will list after 2 weeks. Okay. List along with so and so after 2 weeks. Yes.
Much obliged.
Your Lordship, I beg to mention item number 19, Your Honor. 2 weeks time may be allowed, Your Lordship.
Yes. This is again a quashing matter.
Yes, Your Lordship.
Yes. Just say on prayer made by. You are RPOR.
Yes, Your Lordship.
London Council for the petition. List after 2 weeks. Yes.
Declare.
Much obliged.
Item number 1.
Yes.
Please, Your Lordship. Lordship, in this matter, I have received instruction. I'm praying for some time to file my affidavit, Your Lordship.
Yes. We'll give them some time.
Yes, Lordship.
Yes. One prayer made by Mr. Palal Energy appearing for the state respondents. 2 weeks time is granted for filing counter affidavit.
Yes, obliged, Your Lordship.
Item number 2. For the respondent, Your Lordship. For the board, pollution board. I filed my counter affidavit, my lord.
Your Lordship, I won't be filing a rejoinder, Your Lordship. If Your Lordship can kindly list the matter for hearing, Your Lordship, within a week.
How many respondents are there?
There are 4, Your Lordship.
You have filed affidavit on behalf of?
3. 3.
Respondent number 3. And what about other respondents?
State won't be filing, Your Lordship.
State won't be filing. State is 1 and?
Only 1, Your Lordship.
And who is then 2 and 4?
2 and 4 is the
My lord, I am filing for 2 and 4 also along with respondent number 3.
Okay, so but then you have filed affidavit only. And what about 2 and 4? Any affidavit will be filed? Any?
No, my lord.
No,
We'll be using the same affidavit.
Okay, just see.
It's a small matter, my lord.
Okay, Mr. Pala is for the state. Okay, the Mr. Pala, Lana Council, Lana G appearing for the state respondent submits that no affidavit is required to be filed on behalf of the state respondents in the matter. Then you just say MS Oibang. You are not appearing as a GA here.
No, my lord.
So you see, just correct it. Lord, you have said GA. She will be as a private these things. Okay. So it's
For the pollution board, my lord.
Yes, Miss Bangladesh Council appearing for the petitioner submits that an affidavit in opposition on behalf of the respondent number 3 has already been filed. Stop. However, she submits that there is no requirement of filing of any affidavit on behalf of the respondent number 2 and 4. Stop. MS Mauri, Bangladesh Council appearing for the petitioner pays for grant of some time for filing a rejoinder.
I won't be filing, Your Lordship.
Oh, you'll not be filing?
No, Your
Okay.
Lordship.
Okay, then you just do not say last these things. Then you just say matter is ready for hearing. Then we
Yeah,
can
Your
wait for-
Lordship, we're ready.
Okay, just say the learned counsel for the given next time. Learned counsel for the party submits the matter is ready for hearing. Then you say split for list after 3 weeks for hearing.
Your
Yes.
Lordship. Your Lordship, if I can insist for 2 weeks, Your Lordship.
Why?
Your Lordship,
What is the
it's a
urgency?
succession matter, Your
Okay,
Lordship.
Okay, 2 weeks. This is
A succession
Succession
matter.
matter.
Your Lordship.
succession matter.
Your Lordship.
Okay. Okay, after 2 weeks.
Item number 3.
How much obliged, Your Lordship?
I'm for the petitioner, Your
Yes.
Service is complete, Your Honor. I'll be filing my affidavit for completion of service in a week's time. We've just received on the
Office note
website.
here indicates that the ID card on respondent number 3 and 4 has not.
Then, sir, we'll, my
Okay,
lord,
so
you're appearing for?
okay. 3 and what about 4?
My lord, I can tell you who number 4 is.
4 is UPSC.
I'm appealing on behalf of the MPSC.
So only thing is that about 4 you have to file this thing. A service
fine.
affidavit. Okay. Just say so and so appears for the just write party's name, Mr. Sinkan for respondent number so and so. Then you say
For personal, you appearing for
just say MS Kharwanlam has entered appearance on behalf of the respondent number 3.
personal also. You can.
Stop. 1. However, there is no appearance on behalf of the respondent number 4.
Mr. Order.
Give a paragraph.
Last order.
The office note, the related office note, indicates that service report upon the respondent number 4 is yet to be received. Stop. The petitioner shall verify the status and file a service affidavit in respect of the said respondent within
1 week.
within 1 week. List after 2 weeks.
Hearing item number 4.
May I please, Your Lordship?
Pending,
Yes,
still
Your
pending in the
Lordship.
apex court.
Your Lordship, this is the case.
When it's coming to come up? When is likely to come up, your apex court?
Your Lordship, it was last listed on April. Thereafter, it was supposed to be listed after 8 weeks, but it has not been listed. And summer vacation is also going on, Your Lordship.
So, but the note it is fixed here.
No, Your Lordship.
So, what is to be done then?
Lordship, I'm praying for 4 weeks' time, Your Lordship.
So, on the same ground, that
Yes.
matter is pending.
Yes, Your Lordship.
Okay. Just repeat the last order again. Okay.
Obliged, Lordship.
Yes.
Item number 9.
Lordships, on the last occasion, the instant petition has been admitted.
Yes.
My lords, here, like I've raised at the very outset, that the question of maintainability can be left open, my lord, at the time of hearing.
You should have
No, my lord.
made this submission to the back then.
Your lordships, actually, I have made a submission to your lordships.
Anyway, we will entertain. If you raise the question of
lords.
maintainability, if you say that the revision is not entitlement,
My lord.
definitely, why not?
But the only question, my lord, the petitioner is not
My
here.
lord, petitioner is there.
Yes.
So, my lords, in this matter, your lordship had last time seen the order passed by the district council court. The 18-3, my lords, 2020 order, which is there, my lords, in one compilation that I had shared.
No, what is the order under challenge here?
Because the order under challenge is an order of injunction.
Where is that? Where is that?
Yes, my lords. That order your lordship will find.
You are not a party before the trial court, isn't it?
Yes, my lords, that is the case. I am not the party before the trial court. Page 19 is that order of the main writ petition.
Yes.
And here, my lords, this is a 17th March 2021 order, and it says at the bottom of the page that heard the learned counsel for the petitioner, I have perused the instant application along
Reading at page?
At page 19 of the writ petition.
Yes.
And I am reading, my lords, after the first substantive paragraph, heard the learned counsel for the petitioner.
Yes, yes.
Or I may read, my lords, from the top for the completeness.
Up to you.
So, learned counsel for the petitioner moved the instant application, submitting that on the date of inspection survey on 2nd March 2021, the opposite party number 2, along with 5 to 6 unknown persons, forcefully entered the suit land and stopped the ongoing inspection and the cleaning drive, and it could not be completed. The opposite party also wrote to the officer in charge of Madantring police station. The opposite party has deliberately and willfully disobeyed the order of the Honorable Court, hence prayed to punish the opposite party. Number 3, and direct the OC
See,
of
this is not on this thing.
And then
application order of injunction.
Yes,
this is disobedience. This is disobedience of
Yes,
the.
My lord.
Yes.
Under 39.2.
Compilation page. Compilation page 18.
No, we are concerned about what is there in the petition. Compilation is different.
I am just coming to that. I am coming to the order of injunction also, because that is
that is a violation of. Come to the order of injunction.
Yes. So, my lords, thereafter it says, the second paragraph, heard the learned counsel for the petitioner, I have perused the instant application along with order dated 9/2/2021 and the ad interim injunction order of 18/3/2020.
Yes.
The said order dated 18/3/2020 is still operative. As till date, the opposite parties has not appeared or showed cause to the same. Therefore, the petitioner has the right to enter the suit land for cleaning it. The order on record of 19/2/2021 will also take effect as on 2nd March 2021. The cleaning drive was obstructed. The opposite party number 2 is directed not to disturb the petitioner and the family members during the visit to the suit land, and it will be violation of orders dated 18/3/2020 and 19.
This direction binds the opposite party only.
Yes. 18/3, and my lords, now this direction also reiterates the order which was passed on 18th March 2020.
But then it is more specific now that it will bind only the opposite party.
Yes, my lords. Now, my lords, may just kindly have 18/3/2020. Because at the time when I filed this, I did not have 18/3/2020.
Yes. Where is 18/3?
18/3, my lords, will have. Yes.
What is your prayer here?
My lords, I am just seeking that the injunction against me.
Your prayer is basically against or for quashing of 17/3/2021.
Yes, my lords.
So
I have because
So if it is, with other orders are not a part of this, how can we go through? How can we take
I
cognizance of
appreciate
it?
Milords. Because 18.3 I have only subsequent to the filing of the writ petition when
No,
the
but
lower
then
court
if your challenge is to 18.3 also, then you have to be, this has to be, petition has to be amended then.
Yes, Milords. I follow what is following from your lordship. Even that issue was in my mind. Just for a moment, Milords, sees 18.3. 18.3/2020.
We will not see 18.3 until unless that is not made a part of the record.
Because that is part of the order.
Okay, then we can see it for the purpose of seeing.
Yes, Milords. That is part of the impugned
then
order. That is the only limited purpose is to ascertain the parameters of the impugned order.
Page 17.
Milords may have page 70.
Yes.
So, page 17, this is miscellaneous case 45 of 20 and in title suit 13 of 20. And then Milords may see the subsequent page 18. The instant application is endorsed to my file, disposal wide order dated so and so. Peruse the instant application under order 39, rule 1 and 2, or read with 151 of the CPC for ad interim injunction against the opposite parties. So, the application was made for the purposes of ad interim injunction, and then Milords, directly to page number 20, it is further submitted that the headman and general secretary of Nongpirdi village have issued a certificate to affirm that the petitioner and the opposite party number 1 are joint and rightful legal owner of the suit land, inasmuch as also affirmed that the petitioner is entitled to half the suit land. It was in month of December 2017. The petitioner along with his family members visited the suit land, and during such visit the petitioner was shocked to find that 3 to 4 laborers of MECL were trying to develop the suit land for the purposes to set up a powerhouse. On inquiry, he was informed that they were permitted to use the suit land by opposite party number. Furthermore, opposite parties number 1 and 2 came to visit the petitioner at his residence, inducing the petitioner in believing that since the petitioner has failed to take care of the suit land, they have decided that the petitioner's right title interest over the suit land has ceased to exist. The opposite parties have even threatened the petitioner. It has come to the knowledge of the petitioner that a portion of the suit land was gifted to the performer opposite party to construct a road for the benefit of the inhabitants of village. So and so forth, Milords, and then thereafter the decision is at page 23. Heard the submission of learned counsel for the petitioner, I have perused the instant application with the plaint, which is part and parcel of the application. A bare perusal of the documents on record, the petitioner has a strong prima facie case, as he is in possession of the suit land, having rented it out for cultivation to one Shri so and so for a period of 40 years. Therefore, the petitioner, if the petitioner has who has inherited the suit land, and out of which 50% he is entitled to as such, has every right over the suit land. Hence, the balance of convenience is also in his favor, and irreparable loss will be caused. Then, Milords, the last part is very important. In light of the above, the opposite parties, their employees, agents, associates, or any other persons are restrained from entering and trespassing the suit land or disturbing the peaceful possession of the petitioner over the suit land. So, Milords, an order has been passed in rem against all persons concerned without even giving me an opportunity of being heard. And technically, I could not be in such proceedings.
And then who are you then? Who are you? How do you say that this injunction?
Just sees the order itself. Order itself records at page 21 the contention of the petitioner. The petitioner was shocked to find that 3 to 4 laborers of MECL were trying to develop the suit land. So I was in possession of the suit land. A person who is in possession of the suit land, the proceedings have been initiated.
It further says that on inquiry it was informed that they were permitted to use suit by the opposite party.
Yes.
So that is what the opposite party is the main person.
may or may not, Milords, I am a necessary party because I am at the suit land. And it is a conceded position that I am at the suit land.
See, if you are not a party to the suit, this order will never bind you. It cannot.
Because that clarification will be given then, that if I am not a party, then it will not.
That is what the law
But the-
says. This court doesn't have to clarify it.
That is, but Milords, because they have subsequently filed a complaint, I have all that in the compilation, and after 95% of the project is complete, in a matter of.
Your challenge in this petition is to the order dated 17/3.
Yes, Milords.
So long these other orders are not challenged, we cannot pass any.
So then, Milords may grant me leave. I will amend my prayer clause.
It's for you to do it, but then
Yes,
the
Milord.
thing is that.
Because I could not have challenged.
227 application, what exactly the scope of the court is?
Milords, I have authorities on that. I have authorities on that. There are two things that the court can do. Now, here the situation is that if the inferior court, because Article 227 uses the expression inferior court, if the inferior court goes beyond its jurisdiction, then it is definitely a case of 227, because the inferior court is not acting in accordance with law and going beyond the jurisdiction, or it commits some palpable error within its jurisdiction, which no reasonable person could have come to a conclusion that such is a proper course of conduct. So both situations are giving jurisdiction to this honorable court under Article 227. Now, whether my case.
Where is the violation?
No.
Where is the palpable illegality? Where is the.
Milords, here.
Where is the jurisdictional error?
Here there is. Milords, here the error, jurisdictional error, as per my limited understanding, would be that here the situation is that the district council court is entitled to litigate and adjudicate matters in respect of tribals. It is concededly, with knowing the fact that I am in possession of the property.
How do you say this is just presence of your man doesn't mean that you are a possession?
That is, Milords, part of the plaint. I can show your lordship the plaint.
Is it? What I say? Where is the plaint?
Yes, Milords. Kindly seize the plaint.
At page?
Yes, Milords. Title suit, Milords, is at, your lordship will find it. 129, Milords, yes. Thank you. Of the compilation.
See, compilation has. See, if you are relying on
No,
some
Milords,
documents.
this is the court record. Compilation I have compiled for the convenience of the court.
No. This is a 227 application.
Yes.
Now, if you want us to see some the documents, will it not be a part of the petition?
No, Milords, kindly seize the first order, Milords, that has been passed in this matter. Because, Milords, first order, I express my inability. I, being a complete stranger, I am not even a party. I do not have, Milords, any orders. Neither I have the plaint.
You have your remedy lies somewhere.
So that may be as far as the question.
Now, does it prevent you from taking, even if we assume that what you say it is correct?
Yes, ma'am.
You have your remedy lying somewhere else. 227 is.
No, Milords. For a moment, the remedies, the alternative remedies, Milords, maybe, Milords, I will address as far as the alternative remedies is concerned, is a separate issue. First issue is whether this court can exercise jurisdiction under 227 or not.
Yes.
That is independent from whether I have an alternative remedy or not. Merely because I have I don't have an alternative remedy, this court will not have a jurisdiction. So
no, this court. See, then exercise of jurisdiction becomes discretionary.
Yes,
no
I
question
understand.
Of saying no jurisdiction.
I understand. But here the question is under Article 227, and I have the authorities, if your lordship permits, I will place those authorities. But under Article 227, whether it is a case of me being condemned without being given an opportunity of being heard, principles of natural justice demand that a necessary party be heard.
See, are you saying that 227 is available for enforcement of individual right?
No,
it is not a supervisory jurisdiction. Now 227 will be resorted for implementation of individual right.
No, my lords, there is one thing that if I appreciate that, my lords, but the situation here is
You just show us where which point the court has travelled beyond its jurisdiction. Where is the the gross error of law?
Yes, my lords.
Just say, just show us.
So, my lords, first there are three points, in fact, I will say, which are gross errors of law. First point is that the district council court is a court which, admittedly, it's an undisputed position, exercises jurisdiction over tribals. And I, being a non-tribal, and the court being aware of the fact that I, being a non-tribal and having an interest in the property, still proceeded to pass the impugned order. So, we come up to a situation where district council court...
Where do we get the definition of non-tribal, tribal, non-tribal?
So, my lords, that I will place...
If we had to categorize you...
State is a so, my lords, that is, if that is their case that I am a tribal, then it's another issue.
See, what is their case? It is not there. Here,
No,
this court, if you raise something, it is for you to show it.
Yes, my lords. Yes, my lords.
See,
so I am just flagging my point.
That. They have not come to the picture till now.
I am just flagging my point, my lords. I will show that how a corporate entity framed under section 111 of the Electricity Act is a non-tribal. It's a corporate body. So that aspect, my lords, I will demonstrate. But I am just flagging that there is the first issue that today the district council court is going beyond its jurisdiction because it is deciding issues which concerns non-tribals.
You are stretching your submission too beyond. This, so far as this court understands, so whatever, whatever materials on record reflects.
Right.
This is only an order against tribal individual.
Against tribal individual affecting, if tomorrow the district council court decides the jurisdiction as far as this property of the High Court is concerned.
If you feel that somebody is interfering with your right,
right,
even on the strength of some judicial order, you file a separate suit.
Well, that is why I am saying.
Because you see what you say, the district council court has basically exercised its jurisdiction over you. I don't think it is.
What does Milords then Milords kindly sees the order again, the order which has been passed, because the order is expansive in nature. If that part of the order is removed, I have no difficulty, because the order says all other persons.
See, even for removal, this court has to exercise jurisdiction.
Yes, Milords, and this is a fit case. This is a fit case for exercise of jurisdiction. This court is interested in how the district council courts are proceeding, on what matters they are exercising jurisdiction. That is the power of the superintendents of this court. The district council courts have to act in accordance with law, and that aspect is within the powers of superintendents under Article 227. This is my submission, Lords. 227, the court has wide powers of supervisory jurisdiction. And see,
227 is there to ensure that the subordinate courts functions within the bounds of law.
Right.
That is what, in a nutshell, isn't it?
Yes.
Now, your case is that the trial court, despite knowing there is an involvement of your laborers there, have passed an order.
Right.
There, which should not happen. Because the passing of any order where apparently it is shown by the plaintiff themselves that your people are involved, is basically an exercise of jurisdiction beyond by travelling beyond.
Yes. So that is my
So that gives rise to this.
Yes.
Now, the problem remains is that order dated 17/3 is only under challenge.
Yes, that is there.
And there is no mention of any MSCB official in that order. So until and unless that 18 order, the first order, which you have pointed out right in your compilation.
Yes,
is put under challenge. This is one. Yes, Mr. How you will say, how you explain that part? That this was in your submission.
My lord.
That there his levers are involved there.
My lord, here this is asked.
In spite you choose not to make them party and obtain an order.
My lord, can you have again the injunction order?
Yes. In the compilation.
My lord, in the compilation, page 21.
Yes.
The petitioner was shocked to find that some 3 to 4 laborers of MECL were trying to develop the suit land for the purpose to set up a powerhouse. On inquiry, he was informed that they were permitted to use the suit land by the opposite party. Well, here, the suit land, basically 50% belongs to me and the other 50% to the respondent number 2.
You are a number 2?
My lord, the brothers.
Okay, no. Okay.
I am Power Grid, my lord. I am the executing agency.
Okay, okay. You are with him. Okay, okay. Yes, yes.
I'll give my
yes,
submissions.
yes, please.
Now, my lord, here a suit was filed for a declaration for partition, and the suit was filed against the brother and the Shnong, who permitted some third party to use the suit land. Then again, sir, my lord, an injunction order has been granted in my favor, restraining the opposite parties as well as the agents and the so-called persons. Now, my lord, here, the lordship is very much aware that the orders of the civil court stands at a different footing, my lord, rather than the order passed by the authorities or by the tribunals. Yeah, my lord, here my learned friend is saying that I've exhausted all my remedies. In my humble submission, my lord, no.
No, he has not said so. He said that is a clear case of 227 because the court below has travelled beyond its jurisdiction.
My lord. And he has been hammering, my lord, on that since he belongs to non-tribal, as such, he cannot approach the district council court. But the order 7 of the Meghalaya High Court, jurisdiction of district council rules, kindly provide them the opportunity to file an appropriate application.
How they will do that?
My lord, they can always file an appropriate application.
There only one plea is that, you see, they have nothing to do with the merits and demerits of
my
the
lord.
case. Their only plea is that you have restrained his person. Your order, the order which you have obtained, that has restrained. And district council had no jurisdiction vested in it to pass.
No, but again, my lord, firstly, he is a non-party to a suit. My lord, and again, if he is aggrieved against such orders, remedies are available to him.
No, he cannot go and get himself implemented before the trial court.
No, my lord. I am saying that he can always file an appropriate application before his court, seeking transfer. My lord, that's what.
He may have alternative remedies.
My lord.
Even that may not deter this court from exercising its jurisdiction under 227 if the court is satisfied that the district council has done something which should not have done.
But even then, my lord, even if it is aggrieved against such orders, this is not the proper forum, my lord. Well, I can show some decisions, ladies and gentlemen, on that issue, on this aspect, my lord. That's why I am raising the issue of maintainability.
Yes. What your decisions is? What are the propositions
my
laid down? You do not. Just tell us.
I'll just supply a copy, my lord. Here.
See, Mr. Pandey has to make necessary amendment in his petition. Before that, don't think will.
My lord, here in the apex court.
Because this order, the first injunction order is basically is the main ground of his challenge before this.
My lord, here the consideration before the apex court was that the only question which was required to be determined in this case was whether the High Court, while exercising its power under Article 226 and 227 of the Constitution, is competent to set aside a plain in a civil or private dispute. Here, the Honorable Apex Court is that a petition under Article 226 or 227 of the Constitution can neither be entertained to decide the land or tenant dispute, nor is it maintainable against a private individual to determine an intense dispute, including the question whether one party is harassing the other party.
There is no dispute with that, Mr. Sangma. We are not at all in this.
Because here also the question of third party arises.
There are two things, undeniable things, as Mr. Pandey has said, that from your submissions recorded by the trial court, it is very much clear that his employees were involved. Okay. And he is a non-tribal entity.
He is a non-tribal entity.
Now, these are two admitted facts. Now, if court wanted to pass any order restraining them, you see, he could not have exercised his jurisdiction in your case where you wanted that some injunction be passed restraining them. No, that is something where they have clearly travelled beyond jurisdiction.
No, in my humble submission, I can say no. Because firstly, the suit was filed against the brother and the Shnong, who has allowed him to use the suit land.
No, but then these are, how do you say, this is the clear thing is that this involvement of MUCL employees, that has been specifically recorded. It is not by implication, this is expressly recorded.
My lord.
So an MECL is a separate entity.
My lordships,
If that is your submission that their MECL levers are involved, well, that makes it quite clear that this department was involved here.
well, I would take lordships to the inquiry report, my lord. After the order pass on
But
the
then,
violation.
see, whatever you have submitted, we cannot change.
No, my lordships, I'll show.
Even if we are able to establish some different facts.
My lord. I'm not changing different facts, my lord. I'll show that the suit land belongs to me.
That is all right. You see, you file a suit against proper court. If you want to say that.
My lord, it's always on record, my lord. Lordships just.
It is rather, you see, otherwise we do not know. What land account do you have, Mr. Pandey?
Because I have a patta in my favor.
Patta in your favor?
Yes, my lord. That document is also.
Which authority to you?
Sale deed. Sale deed, my lord. It's a sale deed in my favor or dated 19/4/2018.
Registered sale deed.
Because that's but my instructions were that the.
Now, if you purchase a land, if your claim is that you have purchased, you hold a land.
Right.
That means the application of there must be an exemption of application of the transfer of land transfer right.
Yes.
Now, was it done in your case?
Because that particular thing I have
that means your document is not admissible in law.
No, Milos, that is there.
It loses admissibility. Forget about this.
I understand, but my standing
your only hope is their submission, which is recorded in the injunction.
Their submission also, and Milos, I can demonstrate. I don't want to take your lordship to the nitty-gritty, but I can demonstrate from the application, from the suit, from the prayers, everything is aimed at ousting me from the property.
You see, you should have incorporated all those things in your petition.
I only have one sheet of paper when I approached this honorable court, and then the lower court records were called, and then I was given an opportunity to examine that. That is the difficulty that I face.
Mr. Sagma, do you say that this injunction order is not intended against them?
No, my lord.
And it will not bind them? We will record it specifically.
No, my lord, binding them, my lord, that's what.
Now you say, now you are in problem. If you say it will bind them.
My
lordships,
cannot blow hot and cold at the same breath, saying partly it is not for us and partly it is.
Now he is in trouble. Just allow him to apply his mind and reply.
Well, just kindly peruse the inquiry report.
Now, are you saying that this order will not bind them?
No,
if you make this, we will record this.
I can't make that submissions that this order won't bind them.
If it is your specific case, we will just say. We will record it, we will dismiss their case.
Once this order has been uplifted, then automatically they will start construction again within my land.
Then if you say that, then definitely then it is a clear case. You could not have obtained, you see, this injunction against them from the district council.
No, my lord. Injunction is not
that goes as a clear admission then.
No, my lord. Here, the injunction is not directly against them.
What is your prayer here, Mr. Have you? But then the thing is that you see.
My lord, lots of their prayers with regards to.
What is the prayer in the suit?
My lord.
In the suit, my lord. That suit, my lord, kindly says.
You have not made any prayer for quashing of the proceeding of the title suit.
Oh, of the writ, your lordship.
You have only prayed for interference with the order dated 17/3/2021. Otherwise, you have no problem with the pendency of the suit, Mr.
I have no problem with the pendency of the suit. I just want that the interim injunction, my lords, should.
No, but then you see, like
it has to be.
Injunction is a part of the suit. You see, it cannot be something.
I appreciate, my lords. That requires some amendment.
What is the prayer in the suit?
My lord, kindly have page 6, my lord, of the compilation.
Especially, my lord's prayer, Roman 4. Roman 6, my lord.
And
sorry.
where is the part
Roman
of the
6.
where is the part of the statement in the plaintiff where it says that you are involved?
Yes, but just Roman 6, my lord,
That
sees
was
perpetual
para
injunction.
Para 8, 9 and 19.
Perpetual injunction restraining the defendants, their employees, agents, associates, or any other persons.
That is common. That comes.
Yes.
Any other
And
person
just
who is
sees, my lords, the contentions, my lords.
see, any other person is he claiming through or under them.
Yes, my lords. If my friend is ready to, my lords, concede.
So that through or under them is not reflected in the injunction order.
Yes, my lords. Para 8.
That is why you repeatedly were highlighting that.
Para 8, my lords.
Yes.
Para 8 is the first reference of MECL at page 3.
Yes.
That sometime in the month of December 2017, the plaintiff along with his family member visited. During such visit, the plaintiff was shocked to find that 3 to 4 laborers of MECL were trying to develop the suit land for the purposes of setting up a powerhouse.
Exactly. that takes away matter from the finish. What more?
19 ones, my lord. In this same plane.
Nothing more is needed.
The
That
cause
is
of
good.
action. Cause of action is also because of us. Para 19, my lord. Page 5. If I may, my lord.
Yes, good enough. You correct your petition, Mr.
Yes,
Matter what more is needed?
Hmm.
There's a specific statement by you.
No. This is my adult.
My lord, the issue, if I may, my lord.
Yes.
My lord, it is us who are doing the construction on that land after the land was given to us by MECL.
How do we know that you are doing the construction?
My lord, it's my statement I'm making.
You are nowhere there. You are under MECL.
My lord, I am an independent entity.
Maybe. So far as this case is concerned, you start nowhere.
My lord, my lord, the problem is with regards to that injunction order. That order is being used by them from stopping us from entering into the property for construction.
That we do not know. There is nothing to show it. You see, you can make a statement. If you want to say that you have a rightful claim, you have to go and establish it somewhere else, not in a 227 application.
My lord.
You are.
My lord,
We do not know. Basically, you are not at all required in this petition.
My lord, only assisting.
You can stand only if Mr. Pandey can stand. Otherwise, not.
My lord, I'm only supplementing to what has been submitted only to assist the court, my lord. My lord, the crux here is that the cause of action which comes out, para 19 which we have pointed out, my lord, is that we were working over there for construction of this substation, which is an instrumental and integral part of completing the transmission system. Now, my lord, if this statement is there, that means we were in possession of this suit property.
Not you, MSV.
Well, it was us.
You are a separate entity for us.
My lord, my lord. So, my lord, actually it was us and that suit land through MECL. The property was not in their possession. Whether it was in my possession or MECL's possession, it was not in their possession. It was in our possession. We were working there.
No.
Now, my lord, there are two factors to this. The disputed question of facts are there. They say that the land belongs to him 50% and 50% to defendant number 1. Now, defendant number 1 has filed his WS where he says, I also don't have any right in this property and he also don't have any right in the property.
That's wrong, my lord.
Right, it's a disputed question of fact, I'm saying. I'm not saying that that is the fact. They say that this particular land belongs to us. I'm only, Lordship, trying to be of assistance to the matter here.
See, the problem is that, you see, we can understand. Whatever you say, this cannot take cognizance of all those facts.
My lord.
These are all factual assertions.
My lord.
Even if you establish before this court cannot pass anything basing on that.
My lord. My lord.
Acknowledging your right over the property.
My lord, last, to supplement in the operation of the order, the court below, my lord, the trial court, learned trial court was aware of the fact that state entities, my lord, I'll use the word state entities. The state entities were present on that land and were doing some sort of a construction or development. It is their government. MECL employees were there and they were constructing a powerhouse substation. It was a government work which was underway. Now, knowing the fact, the court has given an injunction order interim.
Where is that? How do you say court knows those?
My lord, it is there in the injunction order itself, this averment. The court has recorded
That's
it.
incorrect.
What?
My lord.
What does it say?
My lord, the court
saying, acknowledging your role in the matter.
Acknowledging that MECL was present in the land.
That is why we are saying, that is why we are entertaining this application.
My lord.
Honestly, Mr. Khera, you do not have anything to say.
My lord.
Basically, your implement is not at all required.
My lord.
Since there was no objection of the petitioner, I will implement. Otherwise, till now, you have no role.
Well, I'm only trying
Maybe
to
subsequently, if you end up fighting in some other court, you may have a bigger role. Okay. Now, only thing is that you see, probably this paragraph 8, which has been pointed out by Mr. Pandey here, that makes a case for interference.
My lord, I may be
Now,
continue
only-
to do the work pending outcome of this suit. I may be allowed to continue with my work.
This court will dispose of this matter.
My lord.
Only provided that that technical problem which is there is corrected. About, because until and unless that main injunction order is challenged, the second order basically concerns only the individual.
Only the
Okay.
violation.
So that is what has to be this thing. And then we do not know, of course. These are all prima facie view. There's something.
Yes.
View may change on the next day also. Mr. Sangma may come up with something else. So we do not know. But then this is one thing is that there is a definitely, you see, like a specific admission of internal things. In such a case, we do not know. You should like. Now, what happens is, supposing if you have to confine to your prayer, and say supposing if you change it also, if this court interferes, then what happens to the suit? Will it be proper for this court to say that the suit was not at all maintainable? Or you'd be only happy if this interim order is interfered with? Some clarification is made that this order will not bind you.
Milord's clarification is made, and this clarification that as far as quo MECL and exercise of jurisdiction over non-tribal, that was incorrect exercise of jurisdiction, that's it.
Exactly, that is what it transfers.
That's
That's
it.
it.
That's
You see, that is all right.
That's it.
Now, what happens if we find that yes, there is a wrong exercise of jurisdiction?
Yes.
Will it not that it will strike at the root of the very proceeding?
It may have the consequence,
And
but
the suit itself will fall.
it may have the but your lordship may not go to that extent of rejecting or of entertaining a proceeding in the nature of Order 7 Rule 11 of rejection of a suit, but it may have some consequences of bearing over the inferior court below, the observations being passed by this court. But that is for the parties who are there to take up the case and will also argue the matter in accordance with the observations passed by the court. Because I am not I am saying that qua me, I am only concerned in respect of my of MECL. As far as non-tribal, because under there is a certain right that the petitioners have to initiate suit of any kind, but it has to be within the parameters of law. So I am saying only to the extent that it affects a non-tribal, and the orders which are against a public project, which is again barred by the amendment to the specific.
That is okay. That is for the court granting injunction to appreciate the public interest.
Yes,
See, along
yes.
with all those other factors, prima facie case,
Right.
grounds of convenience.
Right.
The public interest, involvement of public interest become a vital factor now.
Yes. And
that
now,
is definitely. But then you are not on merits.
No, I am not on merit.
And so far as the merit is concerned, otherwise injunction order is appealable, isn't it?
Appealable order.
Otherwise, normal situation, order of
Because I
injunction
cannot
is
even
appealable.
appeal
You see,
because-
43(1)(r) probably, whatever it is.
Yes, please.
Isn't it?
Yes.
Now, in such a case, revision will not be entertained.
Right.
And even there are decision by the apex court that just to avoid that 1.5 you cannot come up by 2.
Right.
We are not on that. See, you have their 227 application. We have to see whether the court has remained with the jurisdiction or it is
Jurisdiction, yes. Now, just as
that is only one.
There is one additional point which I have not argued, Milord, but just flagging that issue, because now the situation is with the amendment made in the Specific Relief Act in 2020, it has made it mandatory that you will not grant an injunction against a public project. And schedule says electricity project is a public project.
That is what Mr. Khera
Khera
was
is trying.
trying. See, he was harping on that issue right from the very first day.
So if you violate the my submission is my submission is if you violate the provisions of the Specific Relief Act in granting an injunction order, that is also going outside the jurisdiction. So there are multiple things, but
don't think your argument should go to that extent
That-
because
yes.
here is no challenge on
Yes,
merits.
yes.
No challenge on merits. So there is nothing. You see, you will just correct this thing. Just say hard, Mr. Pandey Lana, counsel for the petitioner. Mr. Sangma for signing, sir. You will, Mr. Khera is for, he's for implemented.
Power grid.
Respondent 6.
Respondent 6.
Yes, respondent number 6. Then who are the other respondents who have not appeared?
One is the, two is the private, 3, 4 are
They
the.
had appeared. One of them had appeared.
At least today they are not there. Yes. We'll just record non-appears for the respondent number. Who did not appear?
2, 3, 4 and 5.
2, 3, 4 and 5. Oh, Mr. Sangma is only for one.
Only for one.
Then you will be for 6.
I'm for 6, my lord.
The rest of the respondents are absent, isn't it? 2, 3, 4 and 5.
yes.
Isn't it? Non-appears for one, sir.
At the end of the day, because if they are claiming ownership on the property, which is in dispute, MECL has purchased the property. 2, 3, 4 and 5, I don't see them having any interest to.
It's all right, no problem. Okay. It appears from the submission, just paragraph, it appears from the submission made by the London Council of the petitioners that the main grievance is against it appears that the main grievance of the petitioner is against the order dated 18/3 against an order of an interim injunction against an order of an interim injunction dated 18/3/2020 passed in Miss Case number 44 of 2020 arising out of title suit number 13 of 2020 by the who passed the order?
Presiding officer, Mala. Presiding officer, District Council
Presiding
Court.
officer, district council.
Okay, presiding officer,
Subordinate district.
subordinate district council court, Shillong. Stop. However, it appears that the said order has not been challenged in this revision application, instead a subsequent order dated 17/3/2021 passed in the above case is made the only point of challenge in this petition. Mr. Give a paragraph. Faced with the situation, the learned counsel for the petitioner prays for grant of some time to make necessary amendment. It's a prayer allowed. When shall we do? When shall we have it?
Make it after 2 weeks, Mala.
2 weeks.
Your work is stopped otherwise.
My lord, this is the only portion for which the work is stopped. Now, my
You
lord,
are stopping a public project.
my lord, end of the, my lord,
Is it?
we may be allowed to continue carrying because my lord, the
No,
import.
see, we will not pass any order. We cannot pass any such order except without first deciding the issue of.
My lord,
Without
because
saying something on the issue.
a whole 450 kilometer worth of transmission system is stuck because of this, and it is for nobody else but for the state. My lord, I'll take a moment to
See, this order was passed in 2020.
20, Mala. They have approached last year.
We should not have been sleeping for such a long time. If you come after 5 years and show your urgency, this court will not entertain it. Just pay it out. Just say as prayed for list this matter after 2 weeks. So make the necessary amendment.
Yes, Mala.
Come to these things. What about all the parties to the suit? They are parties.
They are made parties.
Plaintiff and respondents.
Both.
You're the plaintiff there. I'm the plaintiff.
She's the plaintiff.
Nothing. The court gives you a bit trouble, isn't it? Not very smooth.
No,
But then this is how the court learns also.
no, my lord, it is required.
The interaction basically makes the court learn.
Yes,
Otherwise, the best in a lawyer will never come out.
yes, of course. Obliged, my lord.
Blessed.